Not, I'd like to mention item number 32, my lord. Some personal difficulties today, my lord. I have taken consent from the, my lord, opposite party, my lord.
Mr. What is your name?
VK Borwa, my lord.
VK Burwa, learned counsel for the
Applicant, my lord.
applicant who seeks an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the other side regarding his prayer, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed on 13th of May.
Highly obliged, lord.
May I please, your lordship? I am praying for listing in order column, my lord. It is very urgency, my lord. To stay the execution court case, my, on tomorrow, my lord, or Monday, my lord.
Tomorrow we can fix it,
Tomorrow, yes, my.
but tomorrow is holiday.
Oh. Saturday, my lord.
Thursday.
Oh, Thursday,
Friday.
Thursday, my lord.
Okay,
Friday
Thursday.
is a holiday.
Thursday, my lord.
Or tomorrow is a working day.
Yes.
Hmm. Tomorrow, my lord.
Okay, tomorrow.
Oblige me.
Actually, in regard to item number 27, I've circulated the adjournment request. Can it be after 18th of 21st? of
Which
May?
one?
37, my lord.
Heard Mr. A. Das, learned counsel for the
Respondent, sole respondent, your lord.
you have informed the others.
I've taken the consent. Also, the adjournment request circulated, your lord.
And for the petitioner.
Who seeks an adjournment. Also heard Mr. What is your name?
PK Basu.
P.K. Basu,
Yes,
learned
yes, sir.
counsel for the appellant who does not raise any objection. Hence, the prayer is allowed. Let this matter be listed.
After 21st of May, your lordship, on any date.
22nd May.
Much obliged, your lordship.
May please, your lordship. With the consent of the other side, I beg to mention item number 1 of today's lips. Lordship, may
Item number
1, lordship.
1.
Lordship, may the matter be taken after visitation.
Heard Mr. N.M. Datta,
Yes, lord.
learned counsel for the appellant. Also heard Ms. P. Bhattacharya, learned counsel for respondent number
1 to 4.
1 to 4. And learned counsel for the appellants makes and has prayed for an adjournment on the ground of personal difficulty, which is not objected to by the learned counsel for the respondent. Hence, same is allowed. Let this matter be listed. 18th May.
Oblige.
May I please, your lordship? I beg to mention for listing of a urgent matter, lordship, matter April 19 of 24, lordship. This matter is amicably settled between the parties, lordship.
Before Bihudi Day,
Before your lordship, Monday.
7th April.
May I please, your lordship, taking consent from the other side, I beg to mention item number 50, 51, and 52 of the supplementary list. Your lordship may kindly adjourn these matters for 3 weeks, your lordship.
What is your name?
M. Yepto, your lordship.
Learned counsel for the
SC Railways. Item number.
learned counsel for respondent number 2.
My lords, I'm appearing for the appellants.
Raise for an adjournment. Also heard Mr. D. Rathi, learned counsel for the appellant, who does not raise any objection. The prayer is accordingly allowed. Let this matter be listed. 18th of
Much
June.
obliged.
Lordship, I beg to mention item number 8, lordship. Conducting senior counsel is not well, lordship. Matter may be fixed after vacation.
Heard Miss, what is her name?
Spidas.
P. Das, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be 18th of May.
May I please, your lordship? In item number 2, I am for the respondent number 2. And we filed an IA number 872/26. And this not take with the case record. It may be take with the case and one date may be fixed.
I'm for the appellant, lordship.
Heard Mr. What is your name?
And Thakuria for S.
N. Thakuria, learned counsel for respondent number 2, who submits that the respondent number 2 has filed an interlocutory application in this appeal which is not tagged with the record, and hence praise for doing same. Also, Mr.
A Singh Lordship on behalf of RTP.
A. Singh, learned counsel for the appellant, who does not have any objection. Registry to tag the interlocutory application filed by the respondent number 2 along with this record and list the same.
Lordship, the
For
interim order passed in the appeal as well as in the I may be continued, Lordship.
13th of May. The interim order passed earlier in this appeal as well as the in connected interlocutory application shall continue till next date.
May I please, your lordship? Your lordship, I beg to mention item number 4 of today's daily list, your lordship. Can it be adjourned for the day, your lordship, as we are going to file another IA?
But Ms. D. Chauhan, learned counsel for the appellant who prays for an adjournment on the ground that the appellant is intending to file another interlocutory application in this case. The prayer is allowed. Let this matter. 13th of May.
May I please, your lordship? Lordship, I beg to mention item number 3, lordship. The arguing counsel is to fly in from Kolkata. So I request for a date on 24th of April. If that would be possible.
Heard Mr.
AR Pal.
A.
AR Pal for responding.
You have informed the other side.
I'm
Okay.
for that.
Heard Mr. A. R. Pal, learned counsel for the appellant who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. Also, Mr. D. Ullah, learned counsel for the appellant who does not oppose the prayer, hence the prayer is allowed. Let this matter be listed
24th of April.
on 24th of April. Okay, 24th of April.
Obliged.
May I please, your lordship? Lordship, I seek listing of a matter. We have filed a review in a MEG appeal for withdrawal of FDR. Matter was listed yesterday, but it wasn't taken up. Can it be on 6th of April?
After before. 24th. 24th April.
Item 47.
My lord, this matter your lordship heard on Friday, my lord. And your lordship sought and written environments whether I was kept in custody on 15/3/2025 at a police station or not. That I have filed, my lord. Page 92 to 95, my lord. My additional affidavit. Page 92 to 95. There are 3, my lord.
When you were apprehended?
Apprehended on 15/3/2025.
Thereafter?
Then detained, my lord. Thereafter, I kept in custody for whole on 15th.
You are relying on some authority.
Yes, my lord. I have earlier, my lord, my additional affidavit, my lord, kindly see that your lordship heard on Friday, my lord, page 72 to 91. My annexure, my lord, page 76 and page 78. These are the GD entry, my lord. GD entry number 12 and 22. And authorities, my lord, kindly see page 80, annexure 3. On the same footing, my lord, co-accused who have been arrested with me, he was granted bail by the coordinate bench.
Where is the order?
Order, my lord, kindly see. Page 87.
Yes.
Page 87, my lord. Page 88, the land counsel for the petitioner submits that the petitioner have been.
Yes, Mr. Das.
Yes, Lordship. It is there, Lordship. If I look into the records, Lordship, it seems that it is beyond, Lordship, 24
Okay.
hours. And moreover, my only submission is that, Lordship, this is a commercial quantity and 37 is applied, Lordship.
Where is your earlier rejection order?
Earlier rejection order, my lord, kindly see.
It is
Page,
based on,
49,
based on 47 and 48, Lordship.
page 49, earlier rejection order. My lord. That was filed during the course of investigation.
Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Shamimuddin Beg, who has been detained behind the bars since 15/3/2025 in connection with special NDPS case number 28/2025 arising out of Karimganj PS case number 134/2025 registered under section 22C/25/29 of the NDPS Act 1985. Stop. The aforesaid case is presently pending before the Court of Learned Additional Sessions Judge FTC Shri Bhumi. This is for the second time the petitioner has approached this court seeking bail. His earlier application, what is the name of the petitioner?
Shamimuddin Beg.
His earlier application for bail was rejected by this court on 25/7/2025 in bail application number 2080/2025. The gist of accusation in this case is Code Para 3 and 4 from page 50. Learned counsel for the petitioner has submitted that this time the petitioner has approached this court on the ground of violation of his fundamental rights guaranteed to him under Article 22 as well as Article 21 of the Constitution of India. He submits that the petitioner was detained on 15/3/2025 in connection with the aforesaid case after completion of the search and seizure procedure. He submits that same is apparent from the seizure list which was prepared at 2:30 p.m. on 15/3/2025. He also submits that after the completion of the search procedure, he was detained along with the other co-accused and was kept inside the police station, and he was however, he was shown arrest in the arrest memo on 16/3/2025 at 10 AM. And was forwarded to the magistrate, before the magistrate at 3:15 PM on 16/3/2025, which is beyond the period of 24 hours. He further submits that continuation of detention of the petitioner without producing him before the nearest magistrate within the stipulated time of 24 hours is illegal, and it infringes the fundamental rights guaranteed to the petitioner under Article 22 within bracket 2 of the Constitution of India. And as such, his arrest has itself become vitiated. In support of his submission, he has cited a ruling of the Apex Court in the case of Directorate of Enforcement versus Subhash Sharma within bracket judgment dated 21/1/2025 in SLP criminal number 1136/2023. Learned counsel for the petitioner further submits that on the same ground, another co-accused who was arrested, who was also detained along with the present petitioner, has already been granted bail by a coordinate bench of this court in bail application number 356/2026. On the other hand, learned additional public prosecutor has submitted that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable in this case. However, he fairly submits that the search procedure was conducted in the aforesaid case on 15/3/2025 at 2:30 PM, and there is no indication on record that thereafter the petitioner was allowed to go. He, however, submits that the arrest of the petitioner in the arrest memo has been shown at 10 AM on 16/3/2025. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Though on an earlier occasion, the application for bail of the present petitioner was rejected on the ground that embargo of section 37 of the NDPS Act is applicable in this case. However, from the materials available on record, it appears that the petitioner was detained in connection with the aforesaid case at at 2:30 PM on 15/3/2025, and he was not allowed to go thereafter. He was not set free after the seizure procedure. Stop. It appears that the arresting authority has shown the time of arrest of the petitioner at 10 AM on 16/3/2025. Stop. It appears that though the petitioner was detained on 15/3/2025 at 2:30 PM, the police, the arresting authority has shown a later time and date of his arrest, which the arresting authority cannot do. And the continuation of the petitioner in custody without producing him before the nearest magistrate within the stipulated time of 24 hours infringes the fundamental rights guaranteed to him under Article 22 within bracket 2 of the Constitution of India. It is as held by the apex court in the case cited by the learned counsel for the petitioner. Any breach of fundamental rights of the petitioner guaranteed to him under Article 22 of the Constitution of India overrides the embargo of Section 37 of the NDPS Act. As such, as it is apparent from records that the petitioner was not produced before the magistrate within 24 hours of his detention, his arrest becomes vitiated, and on that ground alone, he is entitled to get bail. Accordingly, the petitioner is allowed to be released on bail of rupees 1 lakh with 2 suitable sureties of like amount, with to the satisfaction of learned Special Judge Sri Bhumi. Special Judge Sri Bhumi. Acha. Sri Bhumi.
No, not that.
Sri Bhumi with following conditions. NDPS bail condition Milandip. This bail application is accordingly disposed of.
Not there, Lordship, the co-accused, 2 other central government sureties are also there.
Right.
Okay.
Obliged.
My lord, I am
I
sorry.
had one small correction, special judge slash additional session judge. This is basically pending an additional.
Special Judge come
Additional session.
additional session judge.
Obliged.
My lord, I'm sorry for unusual prayer. Item number 2, Lordship, I am for the respondent number 1, always taking time without informing. Last 2 occasions similar things happen. item two. Here I'm saying item two is already took time.
No, but it was mentioned that you have been informed.
No, Lordship, I have not, I am respondent number one, maybe respondent number two. Respondent two is a separated date.
Oh, no, what is to be done? When is the next date fixed?
I do not know next date is Lordship there, without informing me taking, it. Today was fixed, it was, you have seen, I have two is already taken time.
If you can inform them,
Lordship short the, and they are getting the benefit of interim injunction rejected. I am the seller, Lordship.
council of cover দিব. We'll take it up at 2.
Lordship, obliged.
May it please your lordship. Well, look, this is an appeal filed against an ex parte ad interim injunction order against a Millard newspaper Millard. If your lordship would kindly take the memo of appeal Millard. Where we have
The appearance is complete.
Millard. Yes.
Lordship, so far as I am concerned, we received the copy and all, and we have prepared the affidavit. Today I have to file the affidavit. But the concerned person, Lordship, he is totally extremely engrossed in the electioneering. I could not obtain his signature. So I'm praying for at least 4 days or till 7. He is out of station.
Let them file affidavit.
Millard, my submission is Millard.
The
When
chief
you,
minister
when you
extremely-
obtain ex parte order before the trial court, lordship will kindly see on 27/2/26. My lordship was pleased to grant them time. Now, more than 1 month is over. Thereafter, my lord, on 11/3, I had some personal difficulties because a short adjournment was prayed for. When the other side said that in the month of March, he will not be available. Therefore, matter is fixed today. So, my lord, I have a strong objection to the prayer for injunction, my lord. Affidavit is not going to help anybody's case, my lord, cause in this case. I'll satisfy your lordships from the materials available on record, on their record, my lord. The plaint
No,
itself.
when is the date fixed before the trial court?
29th April, and 2 dates they have failed to file any objection. The response to the interim locutory, the IA as well as the main, they have,
No.
on 2 dates, they did not file.
Well, that's a different thing, my lord. That the honorable trial court will take note of everything. Now, here is a case, my lord. They have obtained an expert interim order. My lord, in view of the latest judgment of the Supreme Court, this is not permissible.
No, before that,
Yes,
if the matter is fixed before the trial court
yes.
and
Matter will definitely be fixed, my lord, because they have obtained an ex parte order.
you
pre-trial
can pray
injunction.
for vacation of that ex parte order before the trial
No,
court.
my lord, no, my lord. It's my right, my lord, under 43(1)(r). They have obtained an, I'll satisfy, it's not a case where the injunction could have been granted. My lord, in respect of pre-trial injunction, especially against media houses, my lord, Supreme Court has laid down additional ground. The learned trial court, my lord, refers to that judgment, some other paragraphs, but that paragraph is not taken note of. It's an absolutely, my lord, an order untenable, my lord. I'll place the
Same could have been told before the learned trial court on the date which was fixed.
No,
This is an ad interim order. This
No,
is an
wait.
ad interim order.
when is the date fixed before the trial court? 20.
Already 2 dates have elapsed,
Next-
they
next
choose
date,
not
I
to
think-
file any objection.
29. No, there's not a question.
When is
When
the,
you have obtained an ex parte order, I have also right to come under appeal. Where is the bar that I cannot come on appeal, Miller?
no, there is no bar.
Yes.
There is no bar. But
No, my lord, my humble submission is the trial court,
no,
Having
you
fixed-
answer my query.
Yes.
When is the next date fixed?
I think it's
29th of
29th
April.
of April.
Before that date, we will fix let them file the affidavit.
Let it be taken up on 7th, Miller.
Not
It is
7.
fixed on 8th. 7th is the last day of electioneering. That night, after 5 PM, it will be silent period. The concerned person will be available after 5. So we'll file the affidavit that night itself. We can give an advance copy. Let it be on 8th.
Let it be on 8th, no problem.
কেতিয়া দিব পাৰি? আমার মতে কি?
Here is a case, Miller. Injunction has been granted because of the status of the plaintiff.
24th.
It's a new law.
24th.
Let it be 8th, Miller. It has got a lot of My lord, this is a case, my lord,
No.
Lordship will kindly see.
Lordship, if the newspaper has nothing to say, actually the person who is aggrieved
Heard, Mr.
should have come. Gaurav
Hey.
should
My
have come.
learned friend need not advise who is to come, who is not to come. I'm for one of the defendant in newspaper.
Heard,
That's why the
Mr.
case assumes importance.
Heard,
So they
Mr.
want to
K.
manufacture news now.
A. N. Chaudhary, learned senior counsel assisted by Mr. B.
Pujit Gayon, my lord.
P. Gayan, learned counsel for the appellant. Also heard Mr. D. Saikya, learned senior counsel assisted by Mr.
Arbor.
Arbor Pujari, learned counsel for respondent number 1. Who are the other respondents?
Gaurav Gogoi, Lordship. The newspaper has no business. The whatever Gaurav Gogoi was saying, they were just reporting. So if the
No,
concerned
whether
person
whether
is happy
notice.
with the injunction order, what is
Notice.
the role of newspaper?
No,
They want to put words in the mouth of Gaurav Gogoi then.
no, we are not going into those issues now.
Now, who is before this honorable in the trial, in the appeal?
Whether notice has been, steps has
One
been.
who understands the meaning of Article 19(1), he knows, my lord, who should come.
Yes.
It's a question of
No,
applicating the
have you
legal
taken
position.
steps for issuance of notice on other respondents?
They're all pro forma, my lord.
No, but you have to take.
Yes,
steps.
yes, we have taken steps. I understand we have taken steps, my lord.
On perusal of the office note dated 30/3/2026, it appears that the notice to respondent number 2 and 3 issued through usual mode have returned after due service. Two and 3. As regards respondent number 4 and 5, you have not taken steps.
We have taken, my lord. I have instructions to submit, we have taken. And the steps was taken by speed post. Huh?
Though learned senior counsel for the appellant submits that the steps for issuance of notice on respondent number 4 and 5 have also been taken, but there is no reflection to that effect in the office note. The office to verify and place the postal track consignment report of notice issued to respondent number 4 and 5 before this court on the next date fixed. Learned senior counsel for respondent number 1 submits that though the affidavit to be filed by the respondent number 1 is ready, however, signatures thereon could not be obtained due to
Ongoing election.
obtained, and he seeks some time for filing the written objection against the application for against the interlocutory application filed by the appellant. The prayer is allowed. Let this matter be listed 24th of April.
Let it
Let
could
it
be on
8, my lord.
27th
No,
of
no,
8, my lord.
no.
Instead of 24th, could it be 27th, the next
27th.
date?
27th April. It is still before the date fixed before the trial court.
Okay, let it be 27th. Huh?
Highly obliged, Lordship.
My lord, the 27th, I understand there is some difficulty. Also, we can prepone it, my lord. Let it be 28, 21, any date.
Then let it be on 24th. I am not there, my colleague will be here, no problem.
24th.
Yes. Highly obliged.
Deeply.
Item 6.
Yes,
Lordship, petitioner before your lordship challenged the impinged order dated 17/1/2026. Thereby, lordship, MACT tribunal returned the claim petition filed by the present petitioner, lordship, on the ground that it has no
jurisdiction.
lordship. But an accident occurred in India, lordship.
How it has jurisdiction according to you?
Lordship, if it is accident occurred in the territorial jurisdiction of the concerned
Okay, I
tribe.
heard Mr. L.R. Mujumdar, learned counsel for the appellant. This appeal under Order 43, Rule 1 within bracket A of the Code of Civil Procedure 1908 has been filed by the appellants impugning the order dated 17/1/2026 passed by the Motor Accident Claims Tribunal Bilasipara in MAC case number 14/2023, by which the application under section 166 of the MB Act filed by the present appellants was returned back to the appellants on the ground of lack of jurisdiction. I have considered the grounds stated in the memo of appeal and have considered the submission made by learned counsel for the appellants. This appeal is admitted. Issue notice to the respondents and call for the records of MAC case number 14/2023 from the concerned tribunal. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 15th of May.
All right.
Item 7.
Yeah, please. Sir. Now, this is an appeal under section 82, subsection 2 of the Employee State Insurance Corporation Act. Minus what has happened against the order of the Employees Insurance Code, whereby I had filed and raised a dispute under section 75.
What is section 82?
82. The provision for appeal, madam. Manoj, has it, Manoj, section 82, subsection 2. An appeal shall lie to the High Court from an order of an employee's insurance court if it involves a substantial question of law.
Okay.
So, Manoj may have the impugn order, which is at page 89. It starts from page 89.
Employees State Insurance Act.
Employee State Insurance Act.
Not this one. Employees.
What's the section 82? Let's have it.
Yes.
Let's at 82. I'll read the subsection 1. Save as expressly provided in this section, no appeal shall lie from an order of an employee's insurance court. Subsection 2. An appeal shall lie to the High Court from an order of an employee's insurance court if it involves a substantial question of law.
60 days. Okay.
So, Manoj, may come to the impugn order, Manoj. It starts at page 89. We had filed an application raising a dispute with respect. I am the employer in this case, Manoj. So we had raised a dispute with respect to the contribution, where under section 75(1)(g) against the corporation. So Then out there is a provision, my lords, that under section 75(2)(b, there is a mandatory pre-deposit, my lords,
Okay,
which can be waived off at the discretion of the insurance code, my lords. My lords may have section 75(2)(b).
yes,
Under 75 says matters to be decided by employees insurance code. And 2B says, my lord, no matter which is in dispute between a principal employer and a corporation in respect of any contribution or any other dues shall be raised by the principal employer in the employee's insurance code unless he has deposited with the court 50% of the amount due from him as claimed by the corporation. There is a proviso, my lord, provided that the court may, for reasons to be recorded in writing, waive or reduce the amount to be deposited under this subsection. My lord, in this case, the waiver was not done, my lord, by the insurance court.
you have prayed for waiver.
We have prayed for a waiver, my lord. At the interim stage, the insurance court had given a waiver, but on the grounds that when the proceedings were initiated under 45A for the contribution, my lord, that I did not appear and that I did not prefer an appeal before, and there is an appellate authority also, my lord, under 45A. That is the reason, my lord, may kindly come to.
Where is the impugn order?
It starts at 89. Minus 91 says, minus may kindly come to page 91, last paragraph. If I may read, my lord.
Yes,
It has been further contended that Messrs. So and so failed to comply with the provisions of ESIC Act for the code number so and so. As such, so-cause notice was served upon the petitioners on 4/4/24.
what was this violation?
Violation was, my lord, there was a demand for our contribution with respect to some additional registration number, my lord. So, and there was a personal hearing conducted where I have, I failed to, it is according to the, it is alleged that I failed to appear, my lord, but there was a representation given that due to my ill health, I couldn't appear on that day, but an order was passed that I have, that with respect to the registration, which I am not entitled to. My registration number is different, my lord. My basic primary contention was that there were two additional registration numbers which were initiated in my name. And they have raised the demand for the contribution of the insurance with respect to the additional numbers, which is not related to me.
What is this code number?
Code number is the this is with respect to the code number, registration number of the factory, my lords, or the factory or the establishment. I have one registration, but the code number which is against which the proceedings were initiated, these were not mine.
Okay,
So, my lords, if I may read, issue to the petitioner affording an opportunity for personal hearing on 22/4/25 and to submit records of contribution and to bring the necessary documents, books of accounts, balance sheet, ledger sheet, salary, so and so. The notice was duly served, but the petitioners neither appeared nor filed any representation. Consequently, in absence of any representation, an ex parte speaking order under section 45A of the ESIC Act was passed on 21/8/24, assessing total contribution payable to the tune of rupees 2,31,000 so and so for the wage period from August 2019, September 23, with a direction to deposit the same within 15 days, failing which recovery under section 45C to 45I would ensue.
who assessed this
My lord.
amount?
There is the assessing officer. There was a proceeding initiated under section 45A, my lord.
Okay, to ascertain your
Yes, the contribution, but we didn't get an opportunity to be heard in that. Well, there were two dates given. We didn't appear, citing ill health, my lords, medical reasons, and we had given a representation, but that was not taken note of. And they had then passed an ex parte order against 45A. 45A says, my lords, there has to be a personal hearing and a reasonable opportunity of being heard must be given. So against that,
This order has not disposed of the case.
no, my lords, this is for to entertain the case by the employees insurance.
You were directed to deposit
Deposit, my lord.
50%.
Yes, my lord. We came against that order, my lord, because we had a prima facie very good case and we have been making
No,
contributions
next date was fixed on 11/2.
for a payment, my lord. For a payment.
Have you made payment
No, my lord, we have come challenging this order, my lord,
after that date, lapse of that date?
after that date, my lord.
What happened on 11/2?
No, no, that. Adjournment was given, my lord, on that.
When is the next date?
Next date. 25/4, my lord. My lord, the employees insurance code has a power to waive off, my lord.
No, power is there,
My lord.
but the conditions necessary to exercise that power.
But in the interim, the employees insurance code has given the waiver, my lord. May
Mm,
kindly come to page
You are directed to deposit only 50%.
50% because, but my main contention is that this registration code is issued not in my name, my lord. It is issued in my name, but I have a different registration code, my lord. There can only be one registration code which can be issued under the act against one factory or establishment, my lord. So
Who is representing the respondents? They
respondent-
don't have standing counsel in this court.
my lord, since it's an appeal, we were not allowed to give an advance copy, my lord.
Okay, what is the substantial question of law?
There's a question of law would, yes, my lord. My lord, may kindly come to the order, my lord, at 92. The waiver was not given on the basis of that I was given an opportunity, I didn't appear. And there is a mandatory provision of section 45 AA that I had to prefer an appeal before the corporation appellate authority. That I had not availed that remedy, my lords, and I straight away came to section 75 before the court. But that is not the case.
No, where is the substantial question of law?
My lords, it's at page 19. Page 19 of the petition, my lords, of the appeal. Whether on the facts of the case and in view of the statutory mandate envisaged under the proviso to section 45A of the ESIC Act, the rules of natural justice require that if a determination is given by the employee state insurance corporation without hearing the principal employer, it will be clearly against the rules of natural justice, madam. My main case is that I was not given an opportunity before the corporation when the 45A proceedings were initiated. 45A said that I have to be given a reasonable opportunity of being heard, madam. But this order was passed ex parte, madam. Thereafter, this second question of law with whether the learned employees insurance code below committed illegality by rejecting to waive off the pre-required deposit of
This cannot be substantial question of law.
Madam, because the order was my waiver was not allowed on the grounds of that I was given I did not appear myself. And there is a mandatory provision under section 45 AA that I had to prefer an appeal, but that is not the case, my lord. That is optional for, I can come directly to the insurance court.
Okay, that may be. What is your name?
N Patiri, my lord.
Heard Mr. N. Patir.
Patiri,
PATIR.
RI.
Patiri, learned counsel for the appellants. This appeal under section 82 within bracket 2 of the Employees State Insurance Act 1948 has been filed by the appellants impugning the order dated 22/1/2026 passed by the Employees Insurance Court, Assam, Kamrup Metro in Miss case number 14/2025 in connection with ESI case number 6/2025, whereby the said whereby the above noted court, whereby the ESI court directed the appellants to deposit 50% of the contribution assessed contribution payable by the appellant under section 45A of the ESI Act. After going through the memo of appeal, as well as considering the submissions made by learned counsel for the appellants, following substantial question of law is formulated in this appeal. Whether the necessity of preferring an appeal under section 45 capital A, double capital A of the Employees State Insurance Act 1948 against an order passed under section 45 capital A of the said act by the Employees State Insurance Corporation is a condition precedent for what is 75(1)(g?
For raising a dispute with respect to the contribution, my lord.
For raising a dispute with respect to the contribution and approaching directly before the Employees Insurance Court under section 75 within bracket 1 within bracket G of the aforesaid act. Stop. Next. Whether the Employees State Insurance Corporation whether the which court violated the principles of natural justice.
My lord, that is the corporation, my lord.
While passing order under 45A, whether the Employees State Insurance Corporation violated the principles of natural justice. What is proviso to 45A?
My lord, proviso to 45A is that no such order shall be passed by the corporation unless the principal or immediate employer or the person in charge of the factory or establishment has been given a reasonable opportunity of being heard.
Well, the principle of natural justice as enshrined in section 45 within 45 capital A of the Employees State Insurance Act 1948. Stop. Whether the employees insurance court committed illegality by refusing to waive of the prerequisite deposit of 50% of the assessed contribution under section 75 capital B of the ESI Act. So this appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order. When is the next date fixed?
27th of April.
Before that date, 24th of April. List accordingly.
Well, can it be on 25th?
25th of April. List accordingly.
23rd.
23rd of April.
Give your wish.
Other side is there.
Item 2.
You have not informed the respondent number 2.
Short time.
In mention, I have mentioned that the case record was not take, and I know the same when I go to the case record in today's morning. And I don't have the contact number of the respondent number 2. We can't see.
When we have given the date.
13th of May.
Okay. Whether the counsel for respondent number 2 have met you,
Pardon, sir.
whether you meet the,
No, sir. Till now, no.
who informed you then? Okay. No, ekaloge aibo lagise. You come to, along with the counsel of respondent number 2 at 2. At 2. We will decide at 2 whether to concede to your prayer or not.
Item 46 from supplementary list.
You know, as per the order passed by this honorable court on last occasion, I have taken steps in main FAO and in both the interim applications. And in the, my lord, in the FAO main 1126, there is an interim direction that till the next returnable date, the respondent is directed to maintain status quo over the suit left. But the pendency of this appeal would not be a bar for the trial court to proceed with the Miss case 85/2026 in its normal course. And thereafter, before the trial court one date was passed, that is on 0503, they have appeared there, but they have not filed any written objection as regards to the interim application, injunction application. And in the trial court, matter has been fixed tomorrow now. That is on 0204. That is the position.
Lordship, today is the first day I'm appearing. Last date we have entered appearance before the trial court and we have filed a petition stating that we have not received the legible copies of the documents. Thereafter, we have received the notice from this honorable court with regards to the FAO. Because my senior friend has approached this honorable court against an ad interim which was not granted to them. So this honorable court has granted status quo order. So in my humble submission, we have already made appearance before the trial court. We'll file objection, trial court may decide the application.
Let the status quo remain.
Yes, till the decision of the miss case.
Till the disposal of the miss case, status quo may be allowed to continue.
Hmm.
Till the pendency of the miss case 46 of 2020, 85 of 2020.
Heard
Miss
Mr.
JK said
A.K. Jain, learned counsel for the appellant. Also heard Mr. F. Faridi, learned counsel for how many respondents? Are
Sole
there?
respondent.
Only one yes.
Sole respondent, who submits that the respondent has entered his appearance in this appeal today only. However, he submits that the present respondent, who is the defendant opposite party in the title suit number 46/2026, as well as Miss J case number 85/2026, pending before the Court of Learned Civil Justice Senior Division, number 2, Kamrup Metro at Gauhati, has appeared before the trial court on, when have you appeared?
5/3.
105.
5th of March.
On 5th of March. It is also submitted at bar that next date of the Miss J case number 85/2026 is fixed before the trial court tomorrow, that is
Second.
2nd of April 2026. Learned counsel for the respondent submits that the respondent will be contesting the Miss J case number 35/2026 before the trial court by filing written objection.
85.
85. Miss J case number 85/2026 by filing written objection. He would also be contesting the title suit number 46/2026 by filing written statement. He submits that the respondent is agreeable to maintain status quo in respect of the suit property regarding the pendency of the Miss J case number 85/2026 before the trial court. Learned 85, Miss J case number 85/2026 before the trial court. The appellant is also, learned counsel for the appellant has submitted that this appeal may be disposed of in terms of the submissions made by learned counsel for the respondents. I have considered the submissions made by respondents. As the parties as the instant appeal was against refusal of the trial court to issue an ex parte ad interim injunction restraining the respondent from continuing with the construction of a Schedule C land, and as parties are agreeable to maintain status quo in respect of the suit property, and as the matter is pending before the trial court, this appeal is disposed of with a direction that the respondent shall maintain Status quo in respect of the suit land or suit property. Sh- In respect of scheduled she land during the pendency of the Ms. J case number 85/2026 before the Court of Learned Civil Judge, Senior Division number 2, Kamrup Metro and Gauhati. The trial court shall make all endeavors to dispose of the aforesaid Ms. J case as expeditiously as possible.
Lordship, trial court should not be influenced by the order of this honorable court. Let respect the previous order.
The observations made by this court in this order shall have no bearing on the trial court while deciding the Ms. J case number 85/2026. This appeal is accordingly disposed of.
Much obliged.
Both connected ayes are also disposed of in view of the order passed in.
Much obliged.
Orders, item 9.
Yeah, please, Your Lordship. Your Lordship, so far respondent number 1 is concerned, Your Lordship. Notice were issued in 2023 November. And office notice there 5/3/26 that AD has not come back. So
You take fresh steps.
the second time, and it is 30-day expired, Your Lordship.
When have you taken steps?
It was issued in November 2023.
23. So yeah,
Thereafter matter didn't.
now you
It
take
came
fresh.
only after I mentioned it.
This time you take fresh steps. Heard Mr. B.K. Jain, learned counsel for the appellant, on perusal of the office note dated 5/3/2026. How many respondents are there?
There are two.
Against two, number
I mean,
2.
it is, they have appeared, but Your Lordship, I like to submit that Amlan Datta, who was representing insurance company, he expired. As per my.
So you take steps again, fresh.
So court notice may be sent to them. They already appeared, filed objection, everything they have done.
That Kili, last name, shows that the notice issued to respondent number 1 has not received back. Stop. Learned counsel for the appellant submits that though the respondent number 2 earlier appeared, however, the counsel engaged by respondent number 2 has expired.
Amlan Datta.
Has expired. In view of these above, the appellant shall take fresh steps for issuance of notice upon respondent number 1 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20th of May. The registry shall issue notice to the respondent number 2 indicating in the notice that the engaged counsel of respondent number 2 has expired and no one is appearing before the court for the said respondent. Let this case be listed again on 20th of May.
Other miscases, same order,
Common order.
common.
Item 10.
May it please your Lordship. Lordship, this appeal was listed on 14/3 in the local levels as item number 2 in court number 7. But both the parties were present, Lordship. That could not be done because Lordship, there is a petition for improvement. In this case, Lordship, what happened is the injured person's father had represented in the and father died. So we filed a petition for improvement. He was the injured person. So that order was not made. Although the parties have appeared, it could not be done on that day.
Otherwise, a settlement has reached.
That means race Lordship. This is the it was there. It can't pass.
Where is the impleadment application?
It's there. Lordship. The application is.
You have filed an,
Yes, Lordship. I have sent notice twice, steps twice.
no, where is the impleadment?
2823, Lordship.
2823, sir.
2823. And they had appeared on in the local lot, but because this order was not passed, it could not be done.
No, 2823. Whether it has been allowed.
No, that was not there. I was to take steps, Lordship. Taking steps as a result of that, they had done this.
Who is the injured?
Injured is before the professor, Sanjeev Burdhan. His father, Tapan Chandra Burdhan, had filed a case on his behalf. And the stay was also granted. We have deposited the 50%, 9,70,500. After the stay, the father died, then we filed a petition. But because of the COVID in between, Lordship, it got delayed also. Filed it in 19, steps taken also in 19, but yeah, I again took steps after COVID. And they have appeared, that day they had come before the law. Mr. Kaur had come there.
No, the notice to them was never issued. And the party was Tapan Chandra Burdhan,
Yes, Lordship, it is issued, Lordship.
who has already expired.
Lordship, these are the dates, Lordship. On 7/9, it's 7/9/20. Steps, Lordship. ID card is annual. No, ID card isn't, but they had appeared, Lordship, on the last occasion. Office note says 21/5/25, no ID card received on R1. But then they appeared in the local. Court order is also there, 22/8/2022.
In Lok Adalat, you did not point out that you have already filed an.
In fact, your parties were there as
Oh,
is in the
okay,
other
okay,
law
okay,
court,
okay.
Lordship. By the time the order was passed.
Then we will allow this impleadment application.
And they may also be disposed of as per his.
No, first we'll allow the impleadment
That will be
application.
done fixed in the maybe
Heard Mr. R.
day
Goswami,
after tomorrow again.
learned counsel for the in IA number 2823. IA number 2823. Heard Mr. R. Goswami, learned counsel for the applicant. Also heard Miss, what is her name?
Krishna Pathak.
T.
TRISHNA, Pathak.
T. Pathak, learned counsel for the injured, namely, you are appearing for
Sanjeev Burdhan.
Sanjeev Chandra Burdhan. This Sanjeev Burdhan. This application under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure has been filed for impleading the injured person, namely Sanjeev Burdhan, in the connected MAC appeal number 123/2017. Stop. Learned counsel for the appellant has submitted that the appellant had filed the connected MAC appeal number 123/2017, impugning the judgment and award dated 5/6/2014, passed by the Motor Accident Claims Tribunal, Sonitpur, whereby the appellant was directed to pay a compensation amount of rupees
19,45,000.
19,45,000 to the claimant. He submits that in the claim case, he submits that though the claim case was filed for claiming compensation in respect of injuries sustained by Sanjeev Bardhan. However, it was filed by his father, late Tapan Chandra Bardhan, on his behalf. He submits that during the pendency of the, when he died,
He died, lordship, when expired. The record is please on the
during the pendency of the,
He died on lordship. 27th. I'll just see the exact date to what is it? As per office note dated 27th notice, he died. Exact date to date of the. Exact date of date is not there. But
not there, has already expired,
expired by the way you received from the.
has already expired. Hence, an application has been made by the insurance company to implead the injured person, namely Sanjeev Bardhan, in the connected appeal. He also submits that in the meanwhile, the parties have also reached an amicable settlement. Stop. Learned counsel for Sanjeev Bardhan does not oppose the prayer, hence the prayer is allowed. This interlocutory application is accordingly disposed of with a direction that the injured Sanjeev Bardhan may be impleaded as respondent number. How many respondents?
There are 3 respondents.
Yes.
1.
Respondent number 1, within bracket 1, in the memo of appeal, now in the connected MAC appeal number 123/2017. You have to file a amended cause title. The appellant shall file an amended cause title showing the newly impleaded name of the newly impleaded respondent in the same. List this matter on 4th of May.
Immediately after the bill also.
April of the
Immediately after the bill. In the meantime, I will file this.
27th April.
Problem.
List accordingly.
11 and 12.
कॉपी नहीं मिला पहली फाइल ये होगा सर का मैं प्ले करूँ ट्रांसलेट करने को Lordship, today we are going to take steps on this one number 4 and 7, my lord. 5 expired, my lord. He is not necessary party, so he may be deleted. My lord.
Heard Miss L. Sharma, learned counsel for the appellant. Also heard Miss R.D. Majumdar, learned counsel for the
Respondent 6.
respondent number 6.
We are also to get a copy, Lordship.
Learned counsel for the appellant has prayed for some more time for taking steps for issuance of notice upon respondent number
4 and 7.
4 and 7 by speed post as well as the usual one. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 4 and 7 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 18th of May. Who is 5?
5 is driver, my lord.
You also
Sandeep Kumar, my lord.
take steps. You take
Clement has informed us today, my lord.
Claimant, my lord. In item number 12, my lord, we have preferred an appeal, my lord.
You are Mr. P.K. Bora.
My lord, my lord.
Also, উপরতে লিখব, also Mr. P.K. Bora, learned counsel for respondent number 1, 2, and 3. You take steps against.
Well, I have given a copy.
No, he's talking.
No, Miss Sharma. উপরত লিখিলে কি 6 and 7 না? And 5, what will you do? 5 has expired.
Yes, my lord. He is driver, not necessary party, my lord. He may be deleted from list or from the list.
Not deleted. The appeal will abate against him.
Then my lord, I will take my lord.
The learned counsel for the appellant further submits that the respondent number 5 has already expired and seeks some time for taking necessary steps in that regard. The prayer is allowed. Let this matter be listed on 18th of May. And this is in item number 11.
Copy to us, Lordship, in 11.
11, the appellant is directed to furnish copy of memo of appeal along with annexures. And whose interlocutory application?
No.
Mami, we have filed, my lord.
As well as the interlocutory application to the learned counsel for respondents within a period of 7 days from the date of this order. Last time also you were directed to maintain.
Brief is your senior's brief, my lord. That's why, my lord, I have to obtain more from the chambers, my lord.
And this time comply. Otherwise, we will dismiss your appeal.
God bless me.
Item number 12. 12 is by whom?
Well, I am
Claimant.
claimant, my lord.
Item number 12. It is for enhancement.
My lord. For enhancement, my lord. Two insurance companies there. my lord.
Notice against respondent number 3. Who is 3?
Oriental Insurance, my lord.
Who you have appeared.
Yes, Lordship. He has given me copy also today.
Time for respond number 6, my lord, in item number 12.
So appearance is complete in this case.
My lord.
What happened to driver?
He strike the outlaw at his own risk.
Then list this matter along with MACK appeal number 446/2018 on the next date is 18/5.
Alia of right, Lordship.
Item 13.
May please, Your Lordship. My lord, in this matter, my lord, there is an office note, my lord. It says that my lord, service upon respondent number 1 and 2 is complete, my lord.
How many respondents are
There
there?
are 3, my lord. Against respondent number 3 already it's served, my lord. There's an order also, my lord, 22/11/2025.
Why this I is for?
I, my lord, is for stay, I think.
Stay.
The record also will have to be called for, my lord. It's a testamentary appeal, my lord. I is for delay of, my lord, 8 days, my lord.
Delay has not been condoned. So appeal is not yet admitted.
Yes.
So we'll condone the delay. How many?
8 days, ma'am.
Heard Mr. S. Das, learned in IA. Heard Mr. S. Das, learned counsel for the applicant. On perusal of the office note dated dated 12/3/2026, it appears that notice issued to respondent number 1 and 2 have been duly served by usual mode. It also appears, where is 3?
3, my lord, there's an order, my lord, 19/11/2025.
1911.
2025.
It also appears there is no order of 1911/2025.
Yes, in the order sheet, my lord, I've seen, my lord, that specific order is there, my lord, to the effect that, my lord, service upon respondent number 3 was completed, my lord.
By 1/2026.
Yes, ma'am.
No. Last line.
Well, it's
Served.
30/11/2022.
It appears from order dated 30/11/2022 that notice issued to respondent number 3 has already been held to be duly served. Hence, the notice on all the respondents, service of notice on all the respondent is hereby complete. This interlocutory application, next paragraph. This interlocutory application where is the application? Has been filed by the applicant Narayan Bishwas, praying for under Section 5 of the Limitation Act, 1963, praying for condoning the delay of 8 days in preferring the connected testamentary appeal, impugning the judgment and order dated 21/9/2017, passed by the Court of London, Additional District Judge Number 2, Nagaon, in title suit within bracket probate, case number 4/2015. After considering the grounds stated in paragraph number 3, 4, 5, and 6 of the instant interlocutory application, this court is of opinion that the applicant was prevented from approaching this court within the prescribed period of limitation for filing the connected appeal due to sufficient cause. Accordingly, the delay of 8 days in preferring the connected testamentary appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to it has already been registered.
My lord, numbering has been done, my lord.
Whether the testamentary,
Test appeal number 1.
no, it has listed today. Will issue notice in testamentary appearance.
Let it come to revision, my after the revision.
Okay, registry is directed to list the connected testamentary appeal for admission on 4th of May.
Value.
Item 14.
May I please be, my lord? Lordship is for office note dated 18/2/2026, Lordship. Response number 1, entire defense by filing of Kalatama, Lordship. And 2 is not returned. LCR has been received. So I have submitted that 2, it is for quantum only. So the appeal may be listed for hearing, Lordship.
Who is 2?
2 is the driver owner, Lordship. Only 2 respondents.
Heard.
LCR received, Lordship.
Heard Mr. A.R. Agarwala, learned counsel for the appellant. Also heard Mr. S. Datta, learned counsel for respondent number
Respondent 1, Your Lordship.
1. On perusal of the office note, it appears that the notice issued to respondent number 2 has not returned back. Learned counsel for the appellant submits that since the instant appeal has been filed by the appellant claimant on being agreed with the quantum of compensation awarded to them, the presence of respondent number 2 may not be necessary for considering the instant appeal. Hence, he prays that the notice to respondent number 2 may be waived. The prayer is allowed. Since the records of MAC case number 62/2016 has been received, has already been received by the registry. This appeal is ready for hearing. List this appeal for hearing on give a date. 8th of, no, in the month of June. 18th of June.
Here also, respondent 1 and 2 entire different.
No, just a minute. Mr. Das, what happened?
Office corrected, my lord, 8 to be 14, my lord.
Accord case, so item number given,
Item 13.
item number 14 not 13 not, instead of 8 days delay, mention 14 days. Yes.
Office not dated 20.
Where is the record?
15.
15. 15.
Yes.
Office not dated 20 February, Lordship, 26 Lords. Respondent 1 and 2 entire appearance by filing Kaltama. 3 is not returned. So 3 divers, so his presence is not necessary, Lordship. LCR has been received.
When have you taken steps for 3?
Lordship, I've taken steps along with the others, Lordship. So 3 is allowed, it is for quantum only, Lordship.
No, that question will come later on.
Yes, Lord.
First, whether you have complied with the directions
Yes,
of
yes,
this.
I've taken steps, Lord.
When?
That office note says, Lordship, 20.
Okay. Heard Mr. A.R. Agarwal, learned counsel for the appellant. Also heard Ms. M. Soikia, learned counsel for respondent number 1, as well as Ms.
J. Ghosh.
J. Ghosh appearing for respondent number 2. Learned counsel for the appellant submits that since the instant appeal has been filed by the appellant claimant on being aggrieved by the quantum of compensation awarded to him, the presence of respondent number 3 may not be necessary in considering the instant appeal. Hence, he prays for waiving the notice to respondent number 3. The prayer is allowed. The records of concerned MAC case have already been received by the registry. This appeal is therefore ready for hearing. List this matter for hearing on 18th of June.
Item 16.
May please, Your Lordship. My lord, this matter, my lord, initially was referred to mediation, my lord. There, my lord, the other side did not come. That's why, my lord, mediation was inconclusive, my lord. So, my lord, may kindly fix it after due vacation, my lord, or in the month of.
Is there hope of
My lord,
settlement?
till now, my lord, mediation, there was no sitting in the mediation, my lord.
Is there any hope?
Yes, Your Honor. My lord, it may be referred to mediation.
Again,
It
and
was
you
also-
will again not appear.
We will appeal, my lord.
A date may be fixed, my lord, for both the parties to appear on that specific date, my lord, before mediation.
No, you talk amongst yourself and then let this court know
My lord.
whether there is a element of settlement. Because even without going to mediation, matter may be settled. Heard Mr. P.P. Das, learned counsel for the appellant. Sorry, heard Mr. S. Das, learned counsel for the appellant. Also heard Miss, what is her name?
B. Talukdar.
B. Talukdar appearing for respondent number. How many respondents are there?
There are 3 respondents. my lord.
You are appearing for
Respondent number 1, my lord.
insurance company.
Yes, my lord.
Respondent number 1, insurance company. it is submitted by learned counsel for both sides that there is an element of settlement in this appeal and therefore prays for some time so that the possibility of settlement in this appeal may be explored. The prayer is allowed. Let this matter be listed. 15th of May.
Item 17.
In this case, my lord, didn't know. Appeal was admitted on 15/6/2022. However, the LCR has not yet received mine.
Till now, it has not.
Yes, my lord.
There's a note that some records are missing from the civil judge. There is a note from the civil judge. Letter from the civil judge.
No, entire record is missing or what?
Or the records, this order sheets, the letter reflects with flag A.
Another reminder may be issued, my lord.
So 2022.
Heard Mr. B.K. Singh, learned counsel for the appellant. Also heard Mr. A. Dhar, learned counsel for the respondent, or sole respondent.
Sole respondent.
Sole respondent. It appears from office note dated 19/3/2026 that the records of the trial court have not yet been received by the registry. It also appears on perusal of letter dated 28/2022, which is there in the case record, which was sent by learned civil judge number 2, Kamrup Metro, to the registry of this court, intimating thereby that though the record of title suit number 131/2014 has been traced out, however, initial order sheets until filing of the written statement are found missing therefrom, and the efforts are on to trace out the said missing order sheets. Stop. Let the Court of Learned Civil Judge number 2 be informed, Civil Judge Senior Division number 2 be informed to send the record to send the trial court record to this court in whatever condition it is found, along with a note thereon before next date. Let this matter be listed again on 18th of May.
Item 18.
May I please? In this case, your lordship, as per order dated 16/12/2025, your lordship, we have taken fresh steps in respect of respondent number 2, your lordship. And accordingly, we have filed an additional affidavit annexing the track consignment, your lordship. That service report has been not sub to the respondent number 2 because, your lordship, due to insufficient address, your lordship. So we have annexed the track consignment.
Now what is to be done?
So my humble submission before your lordship kindly deemed to be served because
How we can deem it to be served?
yes,
When there is a
this, your
report, it
lordship,
is not.
pending since 2022, your
No,
lordship.
but when there is a specific report that it is not served,
Yes, Lordship, because
Then-
it is as per the Form 54, Your Lordship, we have taken a step. I just mentioned in the Form 54, we have taken a step. Police has written the address in the Form 54. We have not personally know the owner of the vehicle also. So there is a difficulties and matters is pending since 2012, Your Lordship. An incident occurred in the year of 2018, Your Lordship. So an appeal
The
basically
appeal is for
for enhancement and insurance by
enhancement.
also
We have already paid the amount, Your Lordship, but the owner the owner is the respondent number 2, and his presence is required, Your Lordship.
Where is track consignment report?
If Your Lordship will take my additional affidavit, Your Lordship, it will be found at page 23, Your Lordship. Annex B, at page 23. And last portion, Your Lordship. Return to sender insufficient address, 23/12/2025. We have taken several steps in respect of this.
No.
Respondent number 1 and
What
2.
the tribunal held, Mr. Datta?
Your Lordship,
Liability of the insurance company to pay the.
to a
compensation.
certain extent, we were supposed to pay as per the insurance policy. We were supposed to pay 5,50,000, and we have already paid. And the other half, the remaining half, that will be 7,50,000. That is about to be paid by the owner.
That was the direction.
Yes, Your Lordship.
Okay, then you have to ensure service. Then substituted mode of newspaper publication. Heard, Mr. What is your name?
S.I. Akan.
S.I. Akan, learned counsel for the appellant. Also heard Mr. S. Datta, learned counsel for respondent number
3, Your Lord.
3. It appears that the appellant was directed to take fresh steps for issuance of notice on respondent number 2, who is the owner of the offending vehicle. However, learned counsel for the appellant has submitted that the notice issued to respondent number 2 by speed post could not be served due to insufficiency of address. And to that effect, he has filed an affidavit along with the postal track consignment report of the notice issued to respondent number 2. He submits that the appellant slash claimant has taken the address of the respondent number 2 from the accident information report within bracket form 54, and no alternative address is available with him. He therefore submits that the appellant may be allowed to take steps for issuance of notice by substituted mode of publication of the notice in the newspapers. The prayer is allowed. The appellant shall take steps by issuance of notice by publishing the notice in the newspaper, in a newspaper which is duly circulated in the area of last known address of the respondent number 2. The date of appearance in the said notice may be shown as 29th May.
Lordship, may I say something? in respect of respondent number one, a service request has been waited, so we can take both of respondent one and two also.
Respondent number?
One also. On divert. Because as per office note, seven, perhaps seven. Service report in respect of one has been awaited.
One be add kar dijiye. Not only two, both one also. By newspaper publication. List accordingly on 18th of 29th of May.
So,
Item 19.
Back to the lordship. There are 5 respondents in this case. There are classes. Respondent 1 is the claimant, he is there, and the insurer of the other vehicle. So there are in fact 2 vehicles in this case. I am the insurer of one vehicle, and insurer of the other vehicle is also there. The rest lordship we have taken twice as several times. So lordship, they will not be required because both the insurers are lordship. In fact, there are a number of cases where entire liability has been discharged by the other insurer. So, lordship, my opinion.
Out of the same accident.
Out of the same accident. MSA case number 211231. I have the judgments of the other cases also with me. So they would not be required. It's a matter of question of how can they do findings.
On whom the notice is yet to be served?
On the owner driver of one vehicle and the owner of the other vehicle. 2, 3, 4.
Respondent number 2, 3, and 4.
In fact, respondent 3, 4 receives, it was received by son on 16/2/2026.
So 4 we can deem.
Yes, it deems to be served lordship. On the office note 16/2/26, respondent 4 received by son. And in case of 3, it was received by some rented person, so that cannot be. That means some tenant probably.
This is item number 19.
19.
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. K. R. Bora, appearing for respondent number 1. And Miss R. Gogoi, appearing for respondent number, M. Setia, appearing for respondent number 5. On perusal of the office note dated 16/2/2026, it appears that notice issued to respondent number 4 was received by his son. Stop. The notice issued to respondent number 4 is accordingly held to be duly served.
And 4 may be struck off also.
Who is driver?
Which driver? 4 is. 3 is the owner of the other vehicle.
You are challenging the liability.
Liability.
Liability,
In
let's say.
all other cases, in all the other restaurants, in the same narration, somehow there is probably typing mistake. Same narration, the other vehicle has been here because the allegation evidence was against the other vehicle only by the claimants.
Respondent number 5, New India lordship.
And according New India has paid the other, satisfied the other judgments. So there can be only one finding of negligence, that is my negligence. In fact, the statements in the judgment also shows.
No. But notice to respondent number, vehicle of the other vehicle, driver of the other vehicle would be necessary. You are shifting liability.
The insurer is already there. In all other cases, they have accepted the liability.
You are accepting the
No,
liability.
accept it.
You are accepting.
They paid their claims.
Another four.
No, if they are accepting the liability, we'll dispose of the appeal.
Lordship.
Yes, Lordship. And the next date it can be disposed of. Our senior is not there today.
Okay.
Ages I can.
Learned counsel for the appellant has submitted that out of the same accident which is involved in this present appeal, there are many other claims case were filed by other claimants. And in those cases, the respondent number 5, that is New India Insurance, has accepted the liability. Of paying compensation. He therefore submits that notice to respondent number 2 and 3, that is driver of the vehicle bearing registration number AS15E3618, as well as owner of the truck bearing registration number AS01H5336 may be waived. Learned counsel for the respondent number 5, however, seeks some time to take instructions and inform this court regarding the submissions made by learned counsel for the appellant. Hence, let this matter be listed again on 18th of May. Let them inform on that day. Then we will decide whether to waive or not. We are not waiving it now. She is not in a position to let her see on 18th of May.
15 of May.
Yeah, please, your Lordship. Yeah, please, your Lordship.
Yes.
Your Lordship, as per office note dated 18/3/2026, no steps or issuance upon respondent number 2 has been received, your Lordship. Your Lordship, I may be allowed to take fresh steps, your Lordship. 1 week's time may be given.
You have not taken steps.
Your Lordship, it appears so. Your Lordship, 1 week's time may be given.
No, but before that you have to explain why have you not taken steps.
Your Lordship, I think it's an inadvertent error on the part of the advocate.
Heard Mr.
K. Talukdar.
A Talukdar. K. Talukdar, learned counsel for the appellant. Also heard Dr. P.K. Goswami, learned counsel for respondent number 1 and 5.
Yes.
1 and 5. Learned counsel for the appellant submits that the appellant would not take steps for issuance of notice upon respondent number 2, as was directed by this court, due to some miscommunication. He therefore prays for allowing some more time to the appellant for taking steps for issuance of notice upon respondent number 2. The prayer is allowed. The appellant shall take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 20th of May.
Dispute is between the brothers and sisters. There is a possibility of amicable settlement. So next date, my lord.
Okay, if it is amicably settled, well and good. You explore.
Yes.
Dr. P.K. Goswami, learned counsel for the respondent number 1 and 5 has submitted that since the parties are related to each other, there is a possibility of amicable settlement. Stop. Since considering the submissions made by learned counsel for the respondent number 1 and 5, the parties are requested to explore the possibility of amicable settlement of the dispute and let this court know about the same on the next date fixed, list accordingly.
Item 21.
I am appearing on behalf of respondent number 1, 2, 5, not 1, 2, and 5.
Okay.
Because this also deflect 1, 2, and 5.
Okay, okay.
1 is mother and 2 to 5 are minor.
1,
2, 5.
1, 2, 3, 4, 5.
1 is mother and 2 to 5 are minor children.
Abhishek, last date may you took
Because this
galti
also
hua hai.
reflect. That's it.
Heard Miss, none has appeared for the appeal is admitted.
No, your lordship, this is delay petition.
Delay. None has appeared for the applicant on call. It appears that on last date also the appellant was absent without any steps. However, Miss B. Sarkar, the learned counsel for 1 to 5, 1 TWO2, TTO2, 1 to 5.
May I please, your lordship? Mr. Arbora is looking over this matter. He, due to personal difficulties, he could not be present today.
Okay.
Your lordship, please short date maybe.
Upar to kati dibo. Heard, Mr. What is your name?
C. Paul.
C. Paul, learned counsel for the applicant who seeks an adjournment on the ground that the conducting counsel, Mr. Arbora, could not appear before this court today due to some personal difficulty. Episode Miss B. Sarkar, the prayer for adjournment is allowed. Let this matter be listed. 4th of May.
Much okay.
Item 22.
May I please, your lordship? Your lordship, this is the delay application. The
1 to 5 is present. Is present. Then prayer for adjournment and now. Yes, Mr.
Your lordship, my delay application before the trial court was dismissed.
Okay.
Now-
Here also you have
Here also some delay has occurred. Your
how
lordship.
many days?
410 days.
Your lordship, my prayer is that my delay may be condoned. And
Are you conceding?
Yes, my lord, the coordinate bench has referred to all the matters regarding continuation of delay by the member of MSCT. That will be referred to the tribunal. If the delay is continued, matter will be also referred.
also remanded. And even recently, the Supreme Court has passed an interim order.
Okay. Heard Mr. D. Mondal, learned counsel for the applicant. Also heard Mr. P. Hajorika,
I'm for respondent 2.
learned counsel for respondent number 2. But notice to other respondents, number
No,
1, who
Notice was issued.
what happened to that?
That was completed.
Who is respondent number 1?
One is the owner cum driver of the vehicle.
Then at least you have to take steps.
Your lordship, I have taken step. Whether it is served or not, I cannot go through the office note, your lordship.
Who is respondent number one?
One is the owner cum driver,
What is the name?
Umesh Kolita.
Okay. It appears from the report of the process server, which is available in the record, that notice issued to respondent number one through usual mode has been duly served on respondent number one. Stop. This, however, none has appeared for respondent number one today. This interlocutory application has been filed under section 5 of the Limitation Act by the applicant Abdul Samad Chaudhry. You were the claimant
Yes, I am the claimant.
/ claimant praying for condonation of delay of 410 days in preferring the connected appeal. Learned counsel for the applicant has submitted that the applicant was suffering from ailment, various ailment, details of which has been mentioned in paragraph number 2 and 3 of the instant interlocutory application. He submits that in the aforesaid paragraphs, the applicant has sufficiently explained the cause of delay in preferring the connected appeal. Stop. Learned counsel for respondent number 2, Mr. P. Hajurika, considering the grounds shown by the applicant in the instant interlocutory application, has not objected to the prayer for condonation of delay. Stop. I have considered the submissions made by learned counsel for both sides. Stop. After going through the grounds stated in paragraph number 2, 3, and 4 of the instant interlocutory application, this court is of considered opinion that the applicant was prevented by sufficient cause in approaching this court for preferring the connected appeal within the prescribed period of limitation. As such, the delay of 410 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission on
Your lordship, my learned friend's name may be reflected while listening.
after a week on a date to be fixed by it. The name of Mr. P. Hajurika may be reflected in the cause list as engaged counsel for the insurance.
Yes.
Insurance.
Highly obliged.
May it please your lordship. My lord, the present case pertains to illegal collection of the penal damage charges by the railway authority, my lord. My lord, the mandatory prerequisite before imposition of penal damage charges is to issue a 48 hours prior notice and to give a.
No, why it has come in
Orders.
orders column.
My lord, the service has been completed, the records has been called for.
Records have been received.
Yes, my lord.
Then we'll fix it for hearing.
My lord, my lord.
Heard Mr. D. Rathi, learned counsel for the appellant. Also heard Ms. R. Devi, Learned counsel for
The respondent lordship.
sole respondent,
Sole
sole respondent. This appeal is ready for hearing. Hence, list the same for hearing on 23rd June.
Much obliged.
Obliged.
Item 24, similar prayer, my lord.
24. What is your name?
24.
24 heard Mr. D. Rathi, learned counsel for the appellant. Also heard Mr. What is your name?
CKS Borwa.
CKS
The
Borwa,
sole respondent.
appearing for the sole respondent. It is submitted at bar that, it appears from record that this appeal is ready for hearing. Hence, list the same for hearing on. You are for?
Lordship, I'm appearing behalf of PS law firm, sole respondent, CGC.
Basically, actually, last actually DSA telephone me, I am carrying the matter. His name is in the listing also. It was DSA papers.
Okay, you resolve.
We both are on the same team. Lord.
Okay, CKS Borwa only. Let this matter be listed for hearing on 23rd June. 23rd June.
Much obliged. Item 25, similar prayer, my lord. 25
successfully.
25. Again, D. Rathi and CKS Borwa. List this matter on 23rd June.
Item
20.
My lord, in respect to item number 26, my lord, this present matter is appeal has been preferred against the order of the execution proceeding, my lord.
Item number?
26, my lord.
Okay.
My lord, this appeal has been preferred against the final order made in the execution proceeding, my lord. And the learned tribunal has went beyond the degree, my lord, granting, my lord, the honorable learned tribunal initially granted 6% interest from the date of the filing until the disposal, subject to the payment being made within 90 days. If the railway fails to make the payment within 90 days, 9% interest will be applicable, my lord. However, railway failed to do so, but learned tribunal has stated that it's a government organization. They are working with a bona fide and this and that, my lord, because of which learned tribunal has went beyond the decree, has only granted 6% interest, my lord.
That 6% you have received.
Yes, my lord, I've received 6%.
The remaining
For 3%, that 9%, my lord, I'm here because they have not made the payment within 90 days as per the original decree, my lord. If it can be disposed of in the order stage, my lord, only
No.
it should.
No, Lord, so because in this particular matter, in fact, the DSA is appearing this matter, Lord, so he informed me.
No, let them appear.
My lord, if a short date can be fixed, only in respect to this matter, not other matters.
No, why short date? Because you have received the bill.
My lord, still 55 lakh, 50 lakhs is still 3% is still 45 lakh, 50 lakh.
So therefore, they are not conceding. So though your submission is that the tribunal went beyond the decree, but we have to decide.
Absolutely.
Heard Mr. D. Rathi, learned counsel for the appellant. Also heard Mr. CKS Borwa, learned counsel for the respondent. Records have
Received, my lord.
This appeal is ready for hearing. List this appeal for hearing on 25th June.
Much obliged, my lord. Similar play in next item. Similar play.
27 also says same order. 25th June.
Much obliged.
Much obliged.
Item 28.
Lordship, TCR is received, Lordship. So item may be fixed for final hearing, Lordship.
Appearance is complete.
Already admitted. Respondent number 1 is already appeared, Lordship, and respondent number 2 and 3, the service is awaited, Lordship, by order dated 8/12/2025, Lordship.
So what happened?
Lordship, that appeal is on the basis of quantum, Lordship. So they are the not necessary party, Lordship. They may be struck off, Lordship.
Third, Mr.
Kakoti, Lordship.
A.
Kakoti.
A. Kakoti.
Lordship, they have already deposited the 30% of the amount,
Awarded
awarded
amount.
amount. I may be allowed the liberty to withdraw the same with due procedure. I'm the claimant here now.
Also heard Mr.
P.
P. Neuk, learned counsel for the respondent / claimant. What happened to mediation, Lok Adalat?
Lordship, there is a negotiation, but amount is not decided. For the purpose, the Lordship mediation is not completed.
Though this matter was earlier referred to Lok Adalat, however, it could not be settled there. Learned counsel for the learned counsel for the appellant has submitted that since this appeal is basically filed on being aggrieved, filed by the claimant / appellant on being aggrieved with the quantum of the compensation awarded to
Claimant, not claimant, Lordship, there is an insurance company. Appeal is filed by the insurance company.
filed by the insurance company on being aggrieved by the quantum of compensation awarded to the claimant. Hence, the presence of respondent number 2 and 3, that is, driver and owner of the offending vehicle, may not be necessary. Hence, praise for waiving the notice. The prayer is allowed. Since the records of since the record of MSC disposed of stay I. Since the record of concerned MSC case has been received, the appeal is ready for hearing. List this appeal for hearing on 25th of June. Learned Mr. P. Neug, learned counsel for the respondent number 1 / claimant, submits that since the insurance company has deposited 30% of the awarded amount in pursuant to the order dated 10/12/2025 passed in IA Civil number 3078/2025 as a condition for grant of stay of the execution of the impugned award. And since this appeal is basically filed agitating the quantum of the compensation, he submits that the appellant may be allowed to withdraw the 30% of the awarded amount which has already been deposited by the insurance company. The prayer is allowed. The registry.
Subject to the submission of the indemnity bond.
No, you are
Insurance company.
basically agreed with the quantum. How much it will be less?
The Lordship, that
If
case
you-
is, CFP case, compassionate family pension, Lordship, on the ground of compassionate family pension. So
Okay.
it will be deducted.
The prayer is allowed. The registry is directed to disburse the 30% of the awarded amount deposited by the insurance company to the registry in accordance with the order dated 10/12/2025 passed in IA Civil number 3078/2025 to the claimant after proper verification, subject to submission of indemnity bond with an undertaking that in the event the appeal is allowed, and if it is required that the respondent shall have to deposit back the said compensation amount, he would be doing so. List accordingly on 25th June.
Item 29.
Await service reports, my lord, on all the respondent, my lord. We have taken steps on 23/2026, my lord, 10 days before.
Okay. Heard Miss L. Sharma, learned counsel for the appellant. On perusal of office note dated 30/3/2026, it appears that notice issued to all the respondents have not yet returned. Stop. The registry is directed to place the track consignment report of notices issued to respondent number 1 to 4 by speed post within on the next date, that is 4th of May. Please.
Reminders to go for TCR, my lord.
Okay. In the meanwhile, the registry shall issue a reminder for requisitioning for sending the MEC case number 1007/2018 by the concerned tribunal.
Obliged.
Made, please, to your lordship. As per the office note dated 16/3/2026, respondent he already has responded. Respondent 1, AD card has not received back and answer noted in regard to respondent number 2.
Take fresh steps.
We have to take instruction because no such person in their address. We have to take instruction. After that, we will take fresh steps in regard to respondent number 2.
Okay, heard Mr. R.K. Mahanta, learned counsel for the appellant. On perusal of office note dated 16/3/2026, it appears that the respondent number 3 has filed wakalatnama in this case, whereas notice issued to respondent number 2 has returned back with an endorsement within inverted comma, no such person returned to sender. Learned counsel for the appellant submits that prays for some time to take proper instruction as regards correct address of the respondent number 2. The prayer is allowed. Let this matter listed on 20 May. Show the presence of Ms. L. Sharma as for respondent number 1. 3.
Yes.
Item 31.
May it please your lordship. Your lordship, respondent number 1 to 3 has already entered appearance. But in respect of respondent number 4, your lordship service report may be awaited, your lordship.
When have you taken steps?
Lordship, notices were issued on 24/1/2026. And the office note date is of 2/3/2026. Lordship, there is no fresh office note.
(24/1).
Lordship.
then it will be difficult to take the postal track consignment. It is beyond 3 months.
Or your lordship, we may take praise.
You take fresh steps.
By register.
Heard Miss P. Thakur, learned counsel for the appellant. Also heard Mr.
Yes, okay.
S. Soikia, appearing for respondent number
2 and 3.
1, 2, and 3. Stop. The office note indicates that notice to respondent number 4 has not yet returned. Stop. The appellant is directed to take fresh steps for issuance of notice upon respondent number 4 by speed post within 7 days from the date of this order, returnable on.
In this case, lordship, respondent number 2 and 3 are minor. So Watatama has been signed by respondent number 1.
Okay.
So we are paying for 1, 2, and 3.
Okay. Please list on 20 in May.
Okay.
Item 33.
May I please your lordship? Lordship, as per order dated 16/3/26, we were directed to take steps for paper publication. But due to certain error in the notice format, there was certain difficulties. So lordship kindly,
You are seeking time.
yes, lordship.
Heard Miss D. Hajorika, learned counsel for the applicant, whose praise for some more time for
Respondent 1.
taking
Steps
steps for issuance of notice by way of substituted mode of publication of the notice in newspaper. Publication of notice to respondent number 1 in newspaper. The prayer is allowed. The applicant shall take steps in pursuant to order dated 9/2/2026 within 15 days from the date of this order. The date of appearance to be reflected in the notice shall be 1st of June. List accordingly. Yes. Yeah. Actually, records. What was your submission?
We file an IA.
Yeah.
Under order 6/17 regarding some correction.
You will be filing.
We file.
You have filed. That is not on record. So that has to be brought on record.
Was the submission on 6/3/2026.
Records.
Was
No.
it will.
File the appellant.
My submission is that earlier, not only today, earlier occasions, same things happened on 20th of February.
No, when
I
have
was
you?
waiting that my matter was not called, then got information it was already passed. Took time by the British Empire. Today, same thing, I came for to move that.
The IA has been numbered as?
8/70/26.
This is a new interlocutory
Just
application.
filed on 17th of March.
Okay.
No copy also served to us.
Heard Mr.
A Singh, lordship, I am for the appellant.
A. Singh, learned counsel for the appellant. Also heard Mr. F. U. Bordbhuya, learned counsel for respondent number 1. As well as Mr. What is your name? What is your name?
N. Thakure.
And Thakure, appearing for respondent number 2, who submits that the respondent number 2 has filed an interlocutory application, that is IA civil number
8/72/26.
872/2026, which is not placed with this appeal. Hence, he prays for listing the matter, said matter along with this appeal. The prayer is allowed. Let this matter, when can we fix it?
After Biju,
13th of May.
13th of May.
Lordship, the interim order
The
passed. when
interim
appeal
order
has been
passed
the
earlier
I-
shall continue till next.
Obliged, Lordship.
Obliged.
Item 34.
My pleasure. Lordship, service towards the respondent number 1, 2, 5, and 7 is completed, Lordship. And as per the respondent number 6, Lordship, he was not residing on the resident, Lordship. As per order dated, office note dated 7/3/2026.
What is your submission regarding 6?
Lordship, the first step may be taken. Lordship, there is an IA for condoning the delay of 108 days, Lordship. The delay may be condoned, Lordship.
No. First you have to ensure service of notice. The appeal has not yet been admitted.
Not admitted.
So far as delay is concerned, I have no objection. I am for respondent number 1 and 2, claimants.
Okay. Heard, Mr. What is your name?
Ekakoti.
Ekakoti, learned counsel for the applicant. Also heard Mr. M. Talukdar, learned counsel for respondent number 1 and 2 / claimants. Where is respondent number 4?
Respondent number 4 appeared, Lordship. They have filed wakalatnama, but today they are not appeared.
Where is the written objection?
They have filed, Lordship. It's on the part of the record.
It is there on record.
Lordship.
You are insurance company.
There's-
Is respondent number
Respondent number
4 is also an insurance company.
The delay was caused due to the office process, Lordship. So that may be condoned.
How much delay?
108 days, Lordship.
Though respondent number 4 has filed a written objection, however, the counsel for respondent number 4 was not found on call. Means the claimant, that is respondent number 1 and 2, have not opposed the prayer for condonation of delay. Hence, the notice to respondent number 6, who is
Driver of the vehicle, Lordship.
offending vehicle,
Offending vehicle.
which there are 2 vehicles.
Vehicle, that is a driver of our vehicle, Lordship. Bus.
Driver of the bus,
Insured with the appellant, present appellant, Lordship.
which bus insured by the present appellant is waived. This interlocutory application has been filed by the United India Insurance Company Limited, praying for condonation of delay of 108 days in preferring the connected MAC appeal. Both the insurance company were directed to pay, or only you were?
Only the United India Insurance Company. Though the search is filed.
Impugning the judgment and award dated 12/11/2024 passed by the Motor Accident Claims Tribunal, Moregaon in MAC within bracket death case number 74/2019, whereby the present applicant was directed to pay a compensation amount of rupees. How much? 24,83,000,
83,000.
along with an interest at the rate of 6% per annum to the claimant respondent. Stop. Learned counsel for the why delay was the reasons for delay.
There is official process for that purpose, delay was caused. Receiving the copy or the office purpose.
The learned counsel for the applicant has submitted that the reasons for delay in filing the connected appeal has been explained by the applicant in paragraph number
3 to 8, Lordship.
paragraph number 3 to 8 of the instant interlocutory application. The main reason cited therein is that the delay has been caused in taking administrative approval of various authorities before filing the connected appeal. Stop. I have considered the submissions made by learned counsel for both sides. The claimant respondent has not opposed the condonation of delay, opposed the prayer for condoning the delay. Though the respondent number 6 in its written objection has raised objection. Respondent number 4 in its written objection has opposed the condonation of delay on the ground that the reasons which are purely administrative in nature cannot be regarded as sufficient cause under Section 5 of the Limitation Act. And it is also submitted that, and it is also stated therein that the time gap, there are some unexplained time gaps in filing the connected appeal by the appellant, which reflects lack of due diligence and casual approach adopted by the applicant in filing the connected appeal as well as the instant interlocutory application. We have it is well settled that while considering an application for condonation of delay under Section 5 of the Limitation Act, a justice-oriented approach has to be taken by the court In this case, it is not a case that the delay has not been properly explained. The applicant has cited reasons of delay in obtaining necessary administrative approvals before filing the appeal. Before filing the connected appeal as the cause of the delay in the instant case. By taking a liberal approach in the matter and more so in the view, more so in view of the fact that the claimant respondent has not opposed the prayer for condonation of the delay. This court is of considered opinion that the reasons cited for delay in filing the connected appeal in paragraph number 2 to 8, 3 to 8 of the instant interlocutory application may be regarded as sufficient cause which prevented the applicant in approaching this court by filing the connected MAC appeal within the prescribed period of limitation. Accordingly, the delay of 108 days in filing the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by.
My name will be reflected.
Name of Mr. M. Talukdar may be reflected in the cause list as engaged counsel for the claimant respondent.
Item 35.
Yes.
Lordship, this matter may be taken up next week.
What is the matter?
Lordship, IA has been filed.
For condonation of
for vacating the interim order. Interim order was passed, the FA.
what interim order?
Interim order for, goes on 26/9/2025. Lordship, please come to.
Why are you seeking adjournment?
Lordship, my senior is out of station. Okay, be given the next week. Lordship, objection was supposed to be filed from their end in the month of February. And it was not done till date.
Objection where? Before the trial court?
No, objection regarding the I. It was.
Yeah, I has been filed by you.
Yes, Lord. Lordship may come to page 58, Annex 3 of FAO.
FAO.
Yes. They're assailing the order dated 22/9/2025, Your Lordship. The Honorable Civil Judge, Senior Division 2.
Page number?
Rejecting the pair of an interim injunction. Therefore, they assailed that order and they come before this Honorable Court.
Now, what has happened to the miss case before the trial court?
That is the order of miscase, your lordship, miscase 900 of 2025. And the order is on page number 58. And
No, whether this miscase has been disposed of,
no, miscase ad interim injunction was
not granted.
not granted.
Now, miscase is pending before the trial court. What is the status of that miscase?
No, miscase is pending, yeah, lordship.
At what stage? You have filed any objection before
No.
the trial court?
We have not
Who-
filed, we
who-
have not filed objection, written objection.
You were the defendant before the trial court.
Yes, lordship, and we have filed a written statement, but written objection was yet to file the miscase. Lordship, they are challenging the reconstituted partnership deed, your lordship. And so far the order is concerned, page number 58, your lordship, paragraph 3 is concerned. May I read your lordship?
No, why this I has been filed?
I has been filed because your lordship, interim order was passed not to disturb, I'm respondent number one.
Where is that interim order?
Interim order is on 26/9/2025.
FAO.
In FAO. In IA, your lordship, page, in IA, your lordship, page number 12.
It is directed that till returnable date.
Yes, it was still
Will
returnable.
not disturb the appellants, more particularly from running the. Okay.
Respondent 1 and 2, your lordship, they're the
okay.
partners of the Eastern Enterprise, your lordship. And they're assailing the reconstituted deed.
We can hear the
Reconstituted.
appeal itself. Final hearing of the appeal. Whether how many respondents are there?
Respondent three respondents are there.
Whether all have appeared?
I'm for all the respondents.
You are, then on next date, the appeal can be heard finally, instead of deciding your interlocutory application. Heard, Mr. In appeal likhibo. Heard, Mr. What is your name?
Yes, Jamal.
S. Jamal, learned counsel for the appearing on behalf of
H. Das.
H. Das, appearing on behalf of H. Das, learned counsel for the appellant. Also, Mr. What is your name?
M. Talukdar.
M. Talukdar, appearing for
Respondent
number 1 and 2.
1, 2, and 3.
1, 2, and 3. Who is appearing for other? 1, 2, and 3.
No, 1, 2, and 3. 1, 2, and 3 are the respondent.
This is item number?
25.
Respondent number 1, 2, and 3.
Note, interim order dated 26/9/25 will be.
It appears that the appearance of parties in the appeal is complete. And the appeal may be finally heard on the next day. Records would not be necessary.
Pardon?
Finally heard on the next date. Let this matter be listed for next day at the stage of admission hearing. Let this matter be listed for admission hearing on.
No, sorted, maybe fixed for lordship, because we are in halt, no business has been run.
Before
So far the respondent 1 and 2 is concerned,
4th of May. 4th of May.
possible.
April, we don't have dates because of Bihu vacation. 4th of May.
4th of May. Keep your watch.
Item 36.
Lordship, here in this case, I am appearing for respondent number 1. Lordship,
Who is for the appellant?
Lordship, counsel for the applicant insurance company informed me that he is out of station. Let the matter be listed on Monday,
Okay.
6th.
This is
Condonation of delay, 25 days only. Service otherwise complete.
none has appeared for the applicant on call. Mr. M. Talukdar appears for respondent number
1.
1, as well as Mr. H. A. Ahmed appears for respondent number 2 and 3. 2 and 3. Let this matter be listed.
On 6th, Lordship.
24th May, 24th April, Bihu, after Bihu.
Small matter, Lordship. Delay condonation petition. Wait.
Let it be 24th April.
Item 38.
May I please, your lordship? Lordship, I have received the copy of the appeal, lordship. I need some time to file my reply, lordship.
May it please, your lordship. Lordship, he may be allowed to file the reply, definitely, lordship. But one observation from this honorable court, I would be requesting, lordship. Lordship, the matter is that the father is not allowed to meet with his daughter, who is around 3 years old. Although there is an order from the family court, lordship, regarding visitation right for the father. Lordship, let them file a reply during the pendency of the petition, lordship. The father may be allowed to meet with the child as per the order passed by the family court, my lord. That observation will be helpful for us, lordship.
What was the order?
Lordship,
Lordship will find it at page number 20,
Page
lordship.
28 is the relevant portion, page 28.
28.
May I read, my lord? A small paragraph. The court is of the opinion that there is no requirement of interference with the custody of the child. Thus, the instant petition of the petitioner seeking custody of the child is rejected. However, the petitioner is granted visitation rights to meet his daughter twice in a week.
How old is daughter?
Our daughter is almost 3 years as of now.
Lordship, as per the instruction I have received, lordship, there is no bar in visiting the child or meeting the child, but the appellant he comes at odd hours. So lordship, I am a working woman. I go. So it is specific. Lordship may kindly read the order. Lordship, it is specifically stated here to meet his daughter twice in a week for 3 hours during holidays or after working hours of the opposite party. So if he comes at odd hours, how can I entertain, lordship?
Lordship, in fact, I have requested also to the women's police station to help us. Even I have messages from the women's police station wherein they have categorically denied the petitioner to meet the daughter, my lord. I have text from the women police station, lordship.
Lordship, I have no instruction as such, lordship. But if he comes and meets during after the office hours of the
that will do. That will do. That observation may be there, my lord.
That is not required. It is already there.
Yes, lordship.
It is already in the order sheet.
It is already in the order sheet, but lordship, they are not allowing us.
Add Mr. R. Karim,
Karim, my lord.
learned counsel for the appellant. Also add Mr.
PP Medhi, lordship.
PP Medhi, learned counsel for the respondent, who seeks some time to file written objection against the contentions raised by the appellant in this appeal. The prayer is allowed.
Lordship, I have a small prayer, lordship.
Yes.
Lordship, my name may be reflected in the constitution.
Yes. The name of Mr. P.P. Medhi shall be reflected in the cause list as engaged counsel for respondent henceforth. Learned counsel for the appellant submits that he does not have any objection to the prayer made by the learned counsel for the respondent for adjournment. However, he submits that since the impugn order, it is the impugn order.
Lordship.
Impugn order.
Impugn order
Page 28.
has allowed the petitioner to meet his minor daughter twice a week for 3 hours during holidays or after working hours of the opposite parties. He may be allowed to meet his daughter. He submits that the respondent is not allowing the appellant to meet his daughter and is not complying with the court's order. On the other hand, learned counsel for the respondent submits that since the respondent is a working lady, it becomes difficult on her part if the appellant visits her in odd hours, seeking his visitation right to meet his daughter. He submits that the respondent does not have any objection to comply with the directions of the family court in the impugn order, provided the appellant comes for meeting his child at an agreed time between the parties.
During holiday, I will be visiting my lord.
Stop. Since there is no stay of the impugn order, both the parties are directed to mutually decide the meeting hours of the appellant so that the impugn order may be complied with during the pendency of this appeal. List this matter again on 21 May.
I'm obliged, Lordship.
Item 39. Item number 39.
None has appeared for the applicant on call. Let this matter be listed on 27th of April.
Item 40.
Lordship, as per office note dated 30 March 2026, Lordship, service report for the respondent number 2 and 1 is awaited, Lordship.
When have you taken steps?
Lordship, the step was taken on 3 March, 3rd March 2026, Lordship.
Okay. Heard Mr.
Ekakoti, Lordship.
Ekakoti, learned counsel for the appellant. Also heard Mr. D. Mondal, learned counsel for the respondent.
Number 1.
Respondent number 1. Office note dated 30/3/2026 shows that the service report in respect of notice issued to respondent number 2 and 3 have not yet received back. Stop. The registry is directed to place before this court the postal track consignment report of notice issued to respondent number 2 and 3 by speed post. Let this matter be listed. April of the track. 29th of April.
Highly obliged.
Item 41.
My lord, service may be awaited on respondent number 1 and 4, my lord.
Lordship, respondent number one is myself, respondent 1 and 2. I have not received any copy. A director by the.
Miss L. Sharma,
There is a mistake in the office note, Lordship.
learned counsel for the appellant. Also Mr. A.R. Agarwala, appearing for
Respondent number 1 and
respondent number 1 and 2, who submits that he has not received
any copy of.
any copy of the memo of appeal. Learned counsel for the appellant is requested to furnish the copy of memo of appeal along with annexures to the learned counsel for the appellant. Respondent number 1 and 2 within 2 days from the date of this order. Office note dated 33/2026 shows that the service report in respect of respondent number
It should be 3 and 4. Lordship.
3 and 4 have not yet returned. You have not taken steps by speed post.
Yep.
You have taken steps by usual post,
Visual.
not usual post, by speed post.
We will take my.
The appellant is directed to take fresh steps for issuance of notice upon respondent number 3 and 4 by speed post within 7 days from the date of this order, returnable on 21 May.
Blessed.
Yes.
Herein, LCR was called for your lordship, but LCR
Parties have appeared.
parties have appeared, your lordship.
I'm appearing for respondent number 1 and 2.
Here the matter is very simple, your lordship. The claim petition of the appellant, it was dismissed on account of non-filing his evidence, your lordship. If kindly, page 23, your lordship, kindly have a look. On some occasion, your lordship, it was the date and but the appellant failed to file his evidence, your lordship. And the date is given on 14/5/2024, 5/7/2024, thereafter 9/10/2024. These are the date.
Why have you filed?
I am only praying, your lordship, for remanding back this matter, your lordship, for with the liberty to allow the appellant to file his evidence, your lordship.
Yes.
Memo back in the honor.
This is
No, let the records come. We will verify.
I am praying only because of that, your lordship, the.
No, for that records would be,
So record, your lordship.
Record is necessary, my lord.
record would be
My
necessary.
lord.
The
And who is appearing for respondent number 4? Heard Mr. A.M. Khan, learned counsel for the appellant. Also heard Miss L. Sharma, learned counsel for respondent number 1 and 2. As well as Mr. What is your name? Z. Rahman, appearing for respondent number 3 and 5. The records of MSC case number 368/2022 has not yet been received. Issue reminder for the same. The registry is also directed to place the postal track consignment report of notice issued to respondent number 4 by speed post on the next date fixed.
My
Let
lord, they
this-
have not furnished a memo of appeal, my lord. with
The
documents, my lord.
appellant shall furnish a copy of memo of appeal along with annexures to the, you have received, to the learned counsel for respondent number 1 and 2. Let this matter be listed accordingly on 21/5.
Wait, please, Lordship. Here in this case, Lordship, service report may be awaited, Lordship. Kindly see office note dated 30 3/2026. Neither regard nor unsub notice has been issued.
Heard Mr. M. Talukdar, learned counsel for the applicant. You have not. Okay. Learned counsel for the applicant. Office note dated 30/3/2026 shows that service report in respect of notices sent to the respondents have not yet been received. Stop. The registry is directed to place the postal track consignment report of notices sent to respondent number 1 to 3 by speed post before this court on the next date fixed. Let this matter be listed on 6th of May.
Item 44.
Lordship, service for the respondent number 3 is awaited, Lordship. As per office note dated 30/3/2026.
Heard Mr. A. Kakuti, learned counsel for the applicant. Also heard Mr. J. Kalita, appearing for this respondent number
1 and 2, Lordship.
1 and 2.
Claimant.
Office note dated 30/3/2026 shows that notice issued to respondent number 3 have not yet returned. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 3 by speed post before this court on the next date fixed. Let this matter be listed on 6th of.
There is an IFR condoning the delay for a period of 349 days, Lordship,
This,
in this appeal, Lordship.
okay. Let the report come.
Condoning delay, Lordship. There is a delay petition, Lordship.
This is the delay
Yes,
petition,
Lordship.
but notice has not yet been served.
Lordship, the claimant respondent is appeared, Lordship. Only the owner cum driver is not appeared. And appeal is on the ground of quantum, Lordship.
Quantum,
So this may be.
Okay. Last paragraph. Learned counsel for the appellant, learned counsel for the respondent, number 1 and 2 / claimant. You are opposing? No. Mr. J. Kalita submits that he has no objection if the delay in preferring the connected appeal is condoned. Since the appellant, the connected appeal is filed by the present applicant on being aggrieved with the quantum of compensation awarded to respondent number 1 and 2, and since the said respondents are not opposing the prayer for condonation of delay, notice to respondent number 3 is hereby waived. I have considered the grounds stated in the interlocutory application for the delay in preferring the connected appeal beyond 349 days of the prescribed period of limitation. Said grounds appears to be sufficient cause which prevented the present applicant in approaching this court by filing the connected appeal within the prescribed period of limitation. Accordingly, the delay of 349 days is hereby condoned, and this interlocutory application is allowed. Registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by registry.
My name may be reflected.
Name of Mr. J. Kulita may be reflected as in the cause list as engaged counsel for respondent number 1 and 2 / claimants.
Memo of appeal.
A copy of
I
memo
shall
of
do.
memo of
No, no,
appeal.
may not be.
I'm not reflecting.
Okay, plus.
And please, your lordship. Lordship, we have filed an IA, the present IA which is listed today. We have filed it because
A4,
IA for rectification of typographical error made in the final order and judgment dated 20th of March 2026.
in which, where is that judgment and order?
Lordship, kindly come to page number 26, annexure B.
Yes,
Lordship, if you come to the last page, which is 28, para 2. If I may read, Lordship.
para 2, yes,
Yes, your lordship. May I please read the paragraph for you?
yes.
It is submitted.
Where is the mistake?
Yes. If you come to the third line, but the said interlocutory application, that is a condonation of delay, has been already disposed of by this court on, it is written 28th of February 2026, whereas it should be 20th of February 2026.
That
This-
is the only mistake.
Yes, this order also has been annexed in this application, your lordship, which is annexure A. Page number 16.
Page number 16 of this IA.
Yes, page number 16 of this present IA. It is annexure A, where we have annexed the previous order as well. If you can see the last, if you can just see the last sentence of this page, your lordship, the date of
Page number?
page number 16.
Yes.
The date of pronouncement of judgment, here it is written 20th of February 2026. This is the rectification that needs to be done in our in the previous order.
Heard Miss
D. Das.
B.
D.
D. Das, learned counsel for the applicant. This interlocutory application has been filed by the applicant in connection with interlocutory application number 469 / what was 469?
469, your lordship. We had filed 469 for to implead our petitioner, Mrs. Meera Saikia, as respondent number.
469 / 2026 arising out of IA civil number 3026 / 2026 in connection with alia appeal number 5153 / 2020. alia appeal is yet to be registered. alia appeal number 515 in in connection with alia appeal bearing filing number 5153/2025. Praying for rectification of a typographical error which has crept in the order dated 2026 in IA Civil number 469/2016. So since the error which has been pointed out by the learned counsel for the applicant is in connection with the date of disposal of an interlocutory application, that is IA Civil number 3026/2025 only, notice to the opposite party in this interlocutory application is waived. So, learned counsel for the applicant has submitted that the interlocutory application whereby delay for the interlocutory application for condoning the delay in preferring the connected appeal, that is IA number 3026/2025, was disposed of by a coordinate bench of this court on 2026. 2026. However, in paragraph number 2 of the order dated 23/2026 passed in IA Civil number 469/2026, it has been mentioned as 28/2026 in place of 20/2026. She submits that as same appears to be typographical error, said error is required to be rectified. I have considered the submissions made by learned counsel for the applicant, as well as gone through the materials on record. On perusal of the records, it appears that the IA number 3026/2025 was disposed of by a coordinate bench of this court on 22/2026. Hence, it appears that in paragraph number 2 of the order dated 23/2026 passed in IA within bracket civil number 469/2026. The date of disposal of the IA civil number 3026/2025 has been wrongly mentioned as 28/2026. Since same appears to be an inadvertent typographical mistake, same is required to be corrected. Accordingly, stop, next para. Accordingly, the dates within inverted, the date within inverted comma 28/2/2026 mentioned in line number 8 and line number 11 of paragraph number 2 of the order dated 23/2026 passed in IA civil number 469/2026 shall be read as 22/2026 instead of 28/2026. This interlocutory application is accordingly allowed and disposed of.
Item 48.
Your Honor, I am appearing for the respondents number 2 and 3 for the owner and driver of the vehicle.
Okay.
48.
Who is for the Mr. A.R. Agarwala is not there. None has appeared for appellant on call. Mr. What is your name?
D. Saikia.
D.
D. Saikia. Devaprat Saikia.
Mr. D. Saikia, learned counsel for respondent number 2 and 3 is present. The notice issued to respondent number 1 has not yet returned back. Stop. Registry to place the postal track consignment report of the notice issued to respondent number 1 by speed post before this court on the next date fixed. The registry shall also send a reminder for the records of MSC case number 1758/2017. List this matter on 6th of May.
Highly blessed.
Item 49.
My lord, as per office note dated 30 March 2026, my lord, please. Record was called for.
Appearance is complete.
Yes. Unless record received.
Heard Mr. I.A. Talukdar, the learned counsel for the appellant. Also heard Mr. S. Ali.
Alim.
S. Alim, learned counsel for respondent number
329.
329, as well as Mr. N.I. Khan, appearing for respondent number 10. Who is appearing for 1 and 2?
What, my lord?
Huh?
What? Your lordship is passing order in MSC appeal or IA?
MSC appeal.
Appeal I am for respondent number 2 to 8.
329 no jagat 2 to 8 likhibo. Instead of 3 to 9, write 2 to 8. Mr. S. Alim, learned counsel for respondent number 2 to 8. Who is appearing for
What, my lord?
K?
What? Junior was there, my lord, but now
Okay, but
Hmm.
none has appeared for the other respondents. It appears that the records of MAC case number 212/2017, which was called for from Motor Accident Claims Tribunal number 2, Kamrup Metro, has not yet been received. Registry to issue a reminder for the same. Release this matter on 13th of May.
My lord, there is a IA.
1-3
My lord, there is.
My lord, after 15, my lord.
after 15. June Dio. 3rd June.
Yes. My lord, there is an IA filed by the appellant under order 41 rule 5 for stay. My lord, 173 is specific that deposit is condition precedent, my lord. That order has not been passed, my lord.
My lord, unless the record comes, that is why the last admission date.
Please, MB Act. Motor Vehicles Act. Let us see.
May I read, my lord?
Yes, 173.
173.
Yes, please read.
Worship got it.
Yes.
Subject to the provisions of subsection 2, any person aggrieved by an award of a claims tribunal may, within 90 days from the date of the award, prefer an appeal to the High Court. Now the provision, my lord, provided that no appeal by the person who is required to pay any amount in terms of such award shall be entertained by the High Court unless he has deposited with it 25,000 rupees or 50% of the amount so awarded, whichever is less, in the manner directed by the High Court. So this is a condition precedent, my lord.
Statutory deposit have you made?
No, my lord.
My
No
lord-
direction, my lord.
My lord.
No,
my
that
lord-
direction is not necessary.
My lord, provided for that the High Court may entertain an appeal after expiry of said period of 90 days if it is satisfied that appellant was prevented by sufficient cause for preferring the appeal. No appeal shall lie against the award of the claim if the amount in dispute in the appeal is less or 1 lakh. My lord, in my case, I am the respondent, my lord, that no such is required.
No, there are two proviso.
Yes.
First proviso says that minimum of 25% or 50%, whichever is less, is a statutory deposit.
Yes, my lord.
Otherwise, appeal is not to be admitted.
Yes.
That 25,000 you have to deposit.
Yes.
Your insurance company.
I am for the respondent, owner of the vehicle. My vehicle was not.
But you were directed to pay.
Yes, I 50-50.
Then you have to pay 25,000.
Then I will deposit my lord.
And this who has filed this IA?
Appellant has filed.
I myself filed against the demand notice, my lord.
You are otherwise opposing this.
Yes, my lord.
You will file any objection,
I have not filed any objection.
or we can dispose of if he deposit 25.
No, my lord. So far, my understanding says there is a tradition in our High Court to direct a deposit of 50%.
When insurance company is involved.
Insurance company is there.
No, statutory deposit is
25.
25,000, whichever is minimum. But for grant of stay, statutory deposit is not for stay.
My lord.
It is for entertaining the appeal itself. For registering the appeal, that 25% is necessary. Then, unless that is deposited, your appeal is defective. Because language is
Clear, my lord.
no appeal can be filed. So otherwise your appeal will be hit by first proviso. It is not, while granting stay, we can give any condition,
My lord, within 1 month, I will. give.
but for entertaining the appeal, that statutory deposit is a must.
So may I pray one thing, my lord? I will file my objection in the IA.
Okay. You deposit that, otherwise your
Yeah, I
appeal
deposit
will
within-
be hit.
I will deposit within a month, my lord. Within the April, my lord, 30 April.
In main appeal of লিখিলে নহয়, তাত continue ৰাখিব. Learned counsel for respondent number 1 and 2.
No, my lord.
Respondent number 2 to
2 to 8.
8 has pointed out that since the appellant was directed to pay the 50% of the awarded amount by the tribunal. Is it right?
Yes, my lord.
50% of the awarded amount by the tribunal. Hence, under first proviso to sections 173 of the Motor Vehicles Act, the appellant is required to deposit the statutory deposit of 25,000 rupees even for entertaining the appeal by the High Court, which he has not yet deposited. Stop. On this, Mr. I.A. Talukdar, learned counsel for the appellant, submits that he may be granted some time for making the statutory deposit. The prayer is allowed. Let this matter be listed again on 3rd of June. In interlocutory application, I.A. Tase, Ayat Likhibo, heard Mr. I.A. Talukdar, learned counsel for the applicant. Also heard Mr. S. Alim, learned counsel for respondent number
3 to 9.
3 to 9, as well as Mr. N.I. Khan, learned counsel for respondent number 10. Learned counsel for respondent number 3 to 9 has prayed for some time for allowing the said respondents to file a written objection against the prayer made by the applicant. The prayer is allowed. The said respondent may do so before the next date fixed. Let this matter be listed on 3rd of June.